So friends, some of you, of course, had joined last week also. So this is, but there are many others who had not come for the last week's this thing. This is, of course, a repetition of what we did last time. I hope it will be useful for people who might not have been able to attend the last session fully, or anyway as a revision. So the objective of this particular program is to ensure that all those of you who were provided our earlier certification training program based on the version which is now recognized as PDPB 2019 need to be actually updated to the new version which has now been presented to the Parliament. The Joint Parliamentary Committee had gone through this PDPB 2019 for nearly 2 years, had consultations with as many stakeholders as possible, and finally has come up with a version which incorporates all their suggestions. Now, this version is presently in the Parliament. Actually, this is presented in the Parliament as an amendment to PDPB 2019, which has already been tabled in December 2019. Therefore, this is not a new bill. It is the existing bill for which the Parliamentary Committee has given its amendment recommendations. So the Parliament can, in a one day or something like that, or one day in each of the houses, can pass this bill without much of further delay. But ultimately, it all depends upon the commitment and intentions of the government. If they want to have an excuse, I'm sure there will be a number of excuses, priorities coming up. But if they want, they can definitely pass this bill during the first week of this budget session itself, because during the second week, perhaps the discussion on the budget itself will start happening. So I presume that from whatever indications we are getting, government would like to get this passed as quickly as possible and provide sufficient time for the industry to actually initiate actions for compliance. So with that objective in mind, we had committed to all the people who had undergone our earlier training programs that we will give a free updation program, and this 3-hour webinar is meant to fulfill that particular obligation. Subsequently, of course, we will be undertaking a separate activity which will include introduction of new training programs, where DPA 2021 will be the base on which we will start discussing. There is no point in discussing the earlier version, except for those of you who want to study the legislative history of DPA 2021. For them, every version is important, because you can always study how the at different points of time the views got modified. But for all other practicing professionals, what is relevant tomorrow is only DPA 2021. Rest of it is for academicians like us to discuss. This was something like this in PDPA 2018. This became so much in 2019. All that is for more detailed discussion of the academicians. So let us go through this particular session from the point of view of tracing some of the changes. Because we are looking at the changes, we will go with some kind of a presumption that you all remember what is there in the PDPB 2019. Only to the extent necessary, we will try to recall it. There are many of our expert members here, so that whenever it comes to making a reference to the previous version, we can always see that we can draw on their memory. Okay, so as we know, the discussion on the current version dates back to the version which was presented after Justice Sri Krishna Committee presented its report. In fact, way back in 2006, actually, the Government of India had drafted something called Personal Data Protection Act, and it had been tabled in the Parliament at that time along with the Information Technology Act Amendment Bill 2006. Then subsequently, the Information Technology Amendment Act 2006 was actually passed as Information Technology Amendment Act 2008, again after a period of 2 years. But this PDPA 2006 somehow was never passed. It was allowed to lapse. Now, after the Aadhaar judgment, that is when Aadhaar was being discussed at the Supreme Court on whether the sharing of information of Aadhaar, linking it with PAN card, etc., is a violation of the privacy of an individual. The government of India, under the direction or compulsion brought by the Supreme Court, formed this committee of Justice Sri Krishna, and that after a period of 1 year, after massive study of data protection laws across the globe, came up with its version, which was called PDPB 2018. Now, this PDPB 2018 was presented, was provided for public comments, but before the public comments could be processed, the term of that parliament expired. So the new parliament came in, and when the new parliament came in, the ministry presented a new version of the bill called PDPB 2019, which was essentially PDPB 2018 plus whatever public comments the government had incorporated. Now, the PDPB 2019 immediately was given to the Joint Parliamentary Committee, and that has now presented its version. So we are now looking at the current version, which is what we call as, in fact, in the bill it says DPA 2021, but since 2021, the bill was not passed, and it is likely to be passed in, say, February 2022. Probably the bill will have to be renamed as Data Protection Act 2022. But anyway, right now, we will call it as Data Protection Bill. Now, for your reference, there is a website called dpa2021.in, where you will be having the section by section details of this particular data protection bill. The particular website also has got a link to a comparison between the earlier version, which is the PDPA 2019 version, and this version side by side for those of you who want to make a quick check. This link is available in the menu of this particular thing, last menu, which simply says C. If you want, you can use that. Additionally, in Naavi.org, I have written a number of articles, about 14 articles, and those of you who are interested may go through that. There is also some discussion about the different aspects of this bill in these articles. Now, this particular act, both PDPB 2019 and DPA 2021, contains 14 chapters, but the 2019 version had 98 sections. Now there is only one additional section, which is section 62. And because of that, the new act now has got 99 sections. Now, up to section 61, the section numbers do not change. Now, because section 62 has been introduced as a new section, the subsequent sections from section 62 to 98 of PDPB 2019 gets renumbered as 63 to 99 here in the new DPA 2021. So other than that, the structure of the data protection regulation remains the same. When we say the structure, you may just keep in the back of your mind how the act has been chapterized. Like there is a chapter which consists of the preliminary aspects, which includes the definitions, which is very important. Then we have got the chapter 2 on obligations, where we look at this data minimization principles, retention, and that kind of a thing, what we call as lawfulness of data processing, or the data processing principles. Then grounds of processing. Then we will be having the personal data of children as a separate chapter, rights of data principles. In India, we call this data subjects as data principles, as against the GDPR terminology of data subject. Same way, GDPR calls the category of processors as data controllers, who determine the purpose and means of processing. In India, we call them as data fiduciaries, because data processors is a term which is used at both the places. So chapter 5 talks about rights of data principles. Chapter 6 talks about the compliance requirement of an organization, the transparency and accountability, which is very important from the corporate compliance angle. Then there is a separate chapter on cross-border transfers. There is a chapter specifically on exemptions. Exemptions are given both to the government as well as to the private sector and public interest activities like journalism and research and so on. Then there will be a chapter on the authority, that is the regulatory authority. In India, it is called Data Protection Authority of India. This is similar to the supervisory authorities in each of the countries under the GDPR. And of course, there, because it is a union, you also need to have a European Data Protection Board. Whereas in India, this particular act is a central act, and we have one data protection authority for India. And within this data protection authority, we may have, of course, sub data protection authorities. You may call him as a deputy director or something. I don't know what kind of nomenclature they give. They may open offices in different regions, and the central office of DPA will be in one place in the country, but there could be regional offices, and there will be persons who will be looking after these regional offices. But the authority will be one, which, because that is like a board consisting of 7 people, so that will sit wherever the DPAI is established. So the powers of that, how the DPA is constituted, all that is there in one chapter. Then there's a chapter on penalties. Penalties are the civil penalties like administrative fines. Offenses are separately discussed in another chapter. Like DPAI, there is another regulatory authority called Appellate Tribunal that will be covered under a separate chapter. Then some miscellaneous aspects like how the funding of this DPAI will be done, etc., is covered. And in all act, there will be a kind of miscellaneous provisions separately given. So that is there in chapter 14. So these are the 14 chapters which were there in PDPB 2019, which will continue to be there in DPA 2021. And except for that one additional section, all the other section numbers will remain. And whatever amendments have been made to specific sections is what we are going to discuss now. Now, when we look at the changes at the broad level, there are about 150 drafting corrections, but these are not very important for us because somewhere the comma, off, for, something like that has been changed. So 150 drafting corrections are only for statistical purposes, but there have been about 81 recommendations, and these recommendations have been, most of them have been incorporated into amendments to specific sections. There are certain recommendations, about 14, 15 recommendations, which have not been incorporated into the amendment. So they remain as the wish list of the Joint Parliamentary Committee. And probably some of that may find a place in the notifications if it is possible, or it may be taken up in the future whenever a further amendment is considered. Now, out of these 81 recommendations, I have considered about 25 recommendations as key recommendations, and that is what we are going to discuss today. Rest of it, of course, they are minor recommendations, and many of these additional recommendations between 25 and 81, you may remember that whenever we discussed, I used to say this is what is going to be the interpretation of that. Some of those interpretations have now been actually converted into specific recommendations. So they are all logical things which followed what was there in PDPB 2019, but where the JPG felt it was necessary, they have made it into specific recommendation. Okay. Now, for the purpose of our discussion, we have classified this into different sections, like how these recommendations affect the applicability of the data, how they affect the definitions of the data, then how they affect the obligations of the data, how they affect the rights, compliance, cross-border transfer, exemptions, penalties, and authorities. So this is roughly the template under which we will be carrying out today's discussions. At any point of time where you feel it is necessary to discuss, you are open to discuss. We will take a small 5 minutes or 10 minutes break somewhere in between, around 11:45 to 12. Rest of otherwise we will try to continue as long as it is required to complete this. Okay. Now, coming to the applicability aspect, the first thing you must all have observed are the press reports about the act becoming responsive, applicable to non-personal data. In fact, this is one of the significant aspects of this particular data. Everywhere else, say we have a Personal Data Protection Act, GDPR is a Personal Data Protection Act. And in fact, the Supreme Court also was more keen on the personal data being protected for the purpose of protecting the privacy of an individual. It doesn't mean that the court or the legislation is not interested in protection of non-personal data, but non-personal data was already being protected both by good business practices like the information by the ISO standards and other things, but also by law, such as the cybercrime laws. For example, in India, when we said Information Technology Act 2000, there is a big part of this ITA 2000, particularly after the amendment in 2008, where there is a lot of discussion on information security. But there, the general perception is information security is required for the purpose of prevention of contraventions, or you can say prevention of cyber crimes. So therefore, the attention of the security features in Information Technology Act has escaped the attention of many of the IS professionals. The lawyers have been looking at it, the police have been looking at it, people who are involved in forensics and cybercrime related things, they are looking at Information Technology Act as a cybercrime law. But a part of the cybercrime law says that organizations need to follow due diligence and reasonable security practices, failing which there will be these criminal and civil penalties which will be applicable to them. So there was substantial part of information security aspects which are already incorporated in law. There was also a regulatory authority called the adjudicating officer. There was an appellate tribunal. So, and the police were having their own prosecution powers. So the non-personal data protection was already covered under Information Technology Act. Worldwide, you may have called the laws as Cyber Abuse Act or something like that. And nowadays, many companies are also talking of Cyber Security Act. Many countries, they are separately passing Cyber Security Act. So Cyber Security Act, Cyber Abuse Act, and Information Technology Act, those kind of acts are already providing for legislative cover for securing non-personal data. So personal data was also included here because these acts like Information Technology Act talk about all kinds of data. It may include personal data, it may include non-personal data. Non-personal data itself may include one category which was earlier personal data, but anonymized now. Anonymized personal data becomes non-personal data. Then within non-personal data, there is corporate data, which is data pertaining to a company, which is not a natural person. There is data related to neither a natural person nor a company, but related to, let us say, the world around us, like the weather data or something like that, or transaction data when I and have an e-commerce transaction, there is a transaction data which emerges out of which is a data which is owned by both the people. And Sri Krishna Committee towards the end of its report also recognized that there is something called community data, where data is shared by different individuals as a group. And it is not a personal data of one individual. At the same time, it involves the personal data of many individuals. And Sri Krishna Committee said that we have not been able to cover this community data as part of our recommendations, but the government can think about it subsequently. And that was when the government of India actually set up another committee called Chris Gopalakrishna Committee, which looked at non-personal data as a separate entity, how to regulate, how to legislate. And there, Chris Gopalakrishna Committee actually came up with two important applications, like how to generate or how to monetize non-personal data. And of course, the rest of the things associated with non-personal data in terms of security was left to the ITA 2000. So the Chris Gopalakrishna Committee focused on monetization of non-personal data. It kept itself completely away from personal data because personal data was covered under the PDPA 2018 at that point of time. And this recommendation was also with the JPC subsequently for reference. And somewhere during the discussions, it was felt that if today we have this data protection, personal data protection legislation, we create a data protection authority, and tomorrow we have to consider another legislation called Non-Personal Data Governance Act. There has to be a separate authority for non-personal data governance. There will be two different authorities, and somehow they got an idea that we should avoid this multiplicity of regulatory authorities. And that is one of the reasons why this act started talking about adding non-personal data into the personal data. But what impact it will have on Information Technology Act, what impact it will have on Chris Gopalakrishna Committee recommendations, these are the things which we need to debate subsequently. Now, keeping this idea that this act should be for non-personal data, and this Data Protection Authority of India, who is set up under this act for the purpose of regulating the personal data protection regulations, should also be a regulator for the data protection of non-personal data, has been now brought into some different sections. Now, if you look at the details of the section, though so much of hype has been created about one single law for personal data and non-personal data, actually within the act, there are very, very minor coverage, you can say, on non-personal data, very minor coverage, unless, of course, in future, the Data Protection Authority starts enforcing more of its powers. Right now, Section 1, which talks about the applicability. When we say applicability, we are talking of the act which says that the provisions of this act shall apply to processing of personal data, processed in India, disclosed in India, kind of a thing. That is one of the criteria which is used for the applicability. If data, which is called personal data, it is called personal data because data is associated with an element of identity which can lead to a living natural person. So such a personal data, if it is collected, if it is processed, if it is stored or disclosed within the geographical boundaries of India, then that comes into the scope of this particular act. Secondly, the act always said that any Indian registered organization, whether it's a company or any other organization like a society, partnership firm, if they are registered under the laws of India, they should be covered under this law. That includes companies which are registered in India, but they are processing personal information of foreign citizens. And that processing can happen either in India or outside India. Now, the question is, why should we be bothered about the processing of personal data of, let us say, a Canadian or a US person or a German? Because we in India as a government has got no constitutional obligation to protect the privacy of a foreign citizen. Their own country's government is responsible for that. So this particular applicability of the act to companies established in India but processing data which is not belonging to Indian citizens was something which could always be considered as an extra reach of our law. Now, GDPR did not think too much about this because they are colonial powers. They always feel that they can make laws for the entire world. But India thought of it and said that we will be able to provide some exemption to the organizations if they come back to us for a notification saying that they have set up a ODC, then this ODC processes only data of some foreign countries, citizens, for which there is a contract. I am not, of course, using it for any crime or anything like that. I have a contract based on which I am processing this data, and there is Personal Data Protection Act in that country, whatever it is. So if we come back to the DPAI with a request, they may be able to notify that this particular data center, we will consider it as exempted from all provisions of this particular legislation, DPA. So that provision has been done in the Indian Act. Now what has happened? Plus, of course, both GDPR and Indian Act says that if a company is established outside India, but it is profiling the citizens of my country or is rendering some business here, that should also come into the scope of this activity. Of course, that is automatically covered by the first section, which says that if data is collected in India, processed in India, then obviously it becomes part of this act. So a company which is doing business in India obviously has data originating from India, and that is covered under this particular act. Now, to this applicability clause, now the government has added the fourth clause, which says the subsection, that is the act, the provisions of this act shall apply to processing of non-personal data, including anonymized personal data. So by bringing it in the initial section 2, the scope of this act has been extended to anonymized personal data. Of course, you know what is anonymization. Anonymization is an irreversible process of de-identifying a personal data, and once it is anonymized, you cannot get back the original identity. That is why every law considers anonymized data as non-personal data. But anyway, to the extent the rest of the 97 sections talk about non-personal data, if any, then this act covers the non-personal data. So please remember that while this says it is applicable, then how it is applicable, you have to search in subsequent sections. Now, the subsequent sections, actually only one important section is section 25, which is data breach notification, where the authority shall, in case of breach of non-personal data, take such necessary steps as may be prescribed. At present, nothing has been prescribed, but this is an empowerment for the DPAI. In terms of data breach notification, however, it will become necessary for an organization to report to the Data Protection Authority both the breach of personal data as well as non-personal data. On personal data, the DPAI may give a lot more instructions on how to handle it. On non-personal data, we do not know what they will do, because already CERT-in is the authority which provides that coverage. So the DPA may actually coordinate activities with the CERT-in. So other than this, under the definition section, data breach has been defined to include the breach of non-personal data, and non-personal data breach has also been defined. There was one section, earlier it was section 91, which actually was also a kind of you can say controversial section at that time. It said that the government has the power, for the purpose of framing any policy for the digital economy, ask an organization, which is a private sector organization, to provide the anonymized personal data in their hands. For example, if Google Map or somebody like that has got anonymized personal data, and if that is going to be useful to the government, the provision was given under section 91 earlier and 92 now, that the government has the power to ask for that information. And some people interpreted this as an overreach of the government to usurp the personal data which has been captured by all the Googles and Facebooks. And that's why there was a confusion. And in fact, one of the reasons why this particular act has now been called as Personal and Non-Personal Data Protection Act is to ensure that the earlier section 91 or the current section 92 is not held ultra vires the ultra vires the act. Okay. Yeah, I think one of the persons is asking for a link now. I am not able to disconnect. Maybe I will do it a little later. Just give me a second. Okay, so to accommodate section 92 not being held ultra vires the Data Protection Act, the government has now expanded the entire section. Okay. Now, in terms of this power, there is a separate recommendation which has also been recorded, which says that this act will prevail over all other laws. See, because there is a definite possibility that the act will be questioned in the Supreme Court as something which was not envisaged by under the Supreme Court recommendation, because Supreme Court recommendation was only for personal data related activities. So there was no need to have legislation for non-personal data, and therefore there is definitely a possibility even now that it may be questioned as ultra vires. But by expanding the scope of the activity of the scope of this act to non-personal data, government has actually ensured against the act or this particular section 92 being held ultra vires the Personal Data Protection Bill. I think that is a strategy which the government has used. Secondly, by adding this recommendation that this prevails over all other laws, the government is trying to reiterate that this is a central law, and tomorrow each state should not say that I will have my own state data protection law, because ITA 2000 is a central law. There is no state-wise laws for Information Technology Act. States are only empowered to make rules under the Information Technology Act as is required for the purpose of implementation. Though some states have tried to use the Police Act and try to bring in regulations, strictly speaking, state governments in India do not have any right to pass laws related to the processing of any information, electronic data. That is how the ITA 2000 was structured as a central law. This law is also structured like that. States do not have the powers, and that is actually specified under this recommendation, where they have given the logic for considering that this is a central law. It prevails over other laws. So wherever it says notwithstanding any other law, it actually overrides every other law, including perhaps the Information Technology Act, which is also a special act. So the committee used that logic and therefore introduced this concept of integrating this personal data and non-personal data together, because of which the title of the bill was also changed from the Personal Data Protection Act to the Data Protection Bill 2021, which becomes the Data Protection Act 2021 or 2022, depending upon the year of its passage. The same thing has also been added in the preamble, because preamble is always very important for determining the legislative intent. So in the preamble, if you see, certain things the government has taken special care is to ensure that in the preamble, it is specifically mentioned that one of the objectives is to ensure the interest and security of the state. Because, you know, some of the privacy critics or critics of the earlier version were telling about the too much powers being given to the government for surveillance and other things. So just as this non-personal data, the other controversial aspect has been the security interests of the government. So now the government in the preamble itself is talking about this as an objective. And also remember that the preamble will also speak about fostering sustainable growth of digital products and services, which means that this act is trying to balance the interest of the protection of privacy with the interest of the government on security, and it does not neglect the interest of business. Say, if you look at any data protection law, how it balances these three different stakeholders' interest is very important. My own view is GDPR has not done a good job of this, whereas we are trying to actually provide that balancing between the multiple stakeholders, government, business, and the privacy activists. So
one question.
Yeah.
See, when you say that it's central law, state cannot make any law. So that should be governed by the concurrentness of the law in the constitution. Is the IT is defined, because at 47 there was no IT, there's nothing. So it is not defined whether it is a state subject or it is a central subject or a concurrent subject. So is the residual is a state subject or concurrent subject or central subject? Is IT defined as central subject or concurrent? If it is a concurrent, that state can also make law. If it is not non-current, is central, then it is only central government which can define define the law. So is it defined in the constitution whether IT is a central or a concurrent? I'm just asking a question.
Okay, so say in Information Technology Act, it is not a law on information technology. Okay, so what it has done there is all the legal provisions of ITA 2000 is directed towards what we call as electronic document. That is a document which is created as a binary expression. So now this binary expression is the essence of the object on which the law has been made on ITA 2000. And obviously it doesn't come under any defined, say, properties, which was there perhaps in the concurrent list and other things. It is something new. The cyberspace is something which is new, like you have got the space above the earth or the sea, certain nautical miles within the seashore. So these are all things which actually are extended geographical boundaries of the nation. So cyberspace is also one such extension. Therefore, it was presumed that these binary expressions, which together constitute the cyberspace, was not considered as a part of concurrent list or this list or that list. It was left as a central government jurisdiction. And by stating, if you go into the ITA 2000, it specifically talks about the powers of the state government, and their powers of the state government is specifically restricted to implementation. Beyond this is a 20-year-old law. Fortunately, nobody actually contested the point which you are making in the year 2000, stating that whether this should be a central law. My argument would have been that this is a law applicable to the cyberspace, and cyberspace is defined as an aggregation of binary expressions. That is all, nothing else. Okay, and that is something which was not defined. If at all it can be defined, it has to be equated to this space, this sea, and other such things which are extensions of the geographical phase, and it would have been perhaps defended like that in the court. Fortunately, that did not come up for any review with the Supreme Court, and I think that law has been settled. There have been one instance in Kerala where the Kerala came up with a Twitter related regulation which was questioned in the High Court, and then the government of Kerala actually withdrew the notification. They didn't contest it. Then earlier in the Police Act, there have been both the Tamil Nadu government as well as Karnataka government passed certain laws, particularly for cyber cafes. Even though the cyber cafe regulation is already there in the Central Act, which was actually ultra wise, but somehow that was not perhaps contested and debated. So let us leave it there. Let us not reopen that controversial subject. My view is that let us look at cyberspace law as different. Let us not give the powers to the state government. In fact, this, you know, that in cyber crime management, it is one of the issues today that because states look at this as a law and order situation, many cyber crimes you cannot actually resolve without the cooperation of the multiple state governments. In fact, there is a need that cyber crime management should be considered like the CBI and other things as a central government thing, like cyberspace should be defined as a different region, and law enforcement in cyberspace should be taken out of the powers of the state government. But of course, you know, a lot of politics and other things will be there. Today, every crime is associated with the cyberspace activity, and therefore it will be very tough to change this. But let us let this.
It's a debatable thing, and a lot of things, because a lot of wheels within wheels are there, and they are,
Yes.
as you rightly said, that states are now having this LEA problem, and everything is related to cyber crime, or most of the things. Most of the criminals are using cyber space for the crime. So a state cannot be detached from that. And at the same time, it should be CBI type of or NIA type of at the center. But that structure has to come out. And it becomes a concurrent list like law and order. But that structure has to come out, and that is evolving, should evolve, that should be formalized. But let's see what happens. But it is good that nobody has contested that it's a concurrent or a state or central subject. It should have been, but good. It is a central subject, and let it remain central subject. Otherwise, there will be conflicting state laws for this.
Yeah. So though it is called Information Technology Act, it is actually a law of against the use and misuse of information. That's all. If you look at that, then information is like an enigmatic object. Nobody can define what is information. So I sometimes use this binary expression. Now, binary expression is zeros and ones, anything which can be made meaningful, thought in terms of binary expressions. That is the electronic document. Because we are all used to the physical world of there should be a document, the document should reside in a server and other things. But actually, you know, in law, electronic document need not reside in a hard disk. It is just a set of binaries. Okay. Now this, if we start looking at that, we will go into a certain philosophical discussion on.
Let's go ahead. Let's take your thing further. DPA 2021.
Yeah. So coming back to 2021, one more recommendation which is very important for us is on the timeline for implementation. Now, this is presently there is a recommendation. There is no specific section, but they have suggested that within the first 3 months after the passage of the bill, they'll let their chairman and members of the DPAI be appointed. Then within 6 months, the DPAI should commence their activities. And within another 3 months, which is 9 months, the registration of data of fiduciaries need to commence. And then by 12 months, the system should be ready with adjudicators and appellate tribunals. Then the companies will be given time up to 24 months for the entire act to become effective. This is what has been suggested, and hopefully this will be accepted in toto when the final bill is
so approximately 3 years is what we as in companies
2 years.
will get?
2 years from the all this date is calculated from the date of notification of the act. That is after the passage in the parliament. Normally within a week the president will sign the assent note. That is the date of note. There it will be mentioned as what is the notification date.
And after that notification will be there. After president sign and notification maybe after 6 months also. So
It
that
could be.
date of notification is the date of act, not the president signs.
Yeah. Normally, once it is passed, the date of notification will be concurrent with that, but the government can say that it will be notified with effect from such and such a date. So accordingly, date of the notification will determine this zero date, and then other things will come within that. So totally 2 years time is likely to be there.
Sir, one quick question, sir, Rajesh here. So when we talk from the timeline standpoint, are we looking at each of it successive in nature, that one after the other, or is it been parallel? Because 3 months for
we don't know. In fact, between the 12 and 24 months, so for example, registration would have been done by the from 9th month onwards up to 24 months. Let us say a registration should happen. Probably 24 months will be the time before the penalties would start kicking in. That's all we can say at this point of time. And within this, currently the Act says that for different provisions, different dates of notification can be given. So that remains in the Act, and even with this kind of a time schedule, the government can still say that registration should be completed within 12 months, that is 3 months. But if registration has to be completed, you have to have the privacy by design policy. So which means that most of your compliance template should be ready before registration. Registration is not the name and address of the company like your GST registration or something like that, because registration of significant data fiduciaries require filing of privacy by design policy. Privacy by design policy under this Act is much different from the concept of privacy by design under GDPR, where it is an obligation to implement the policy with the company. Whereas here, you have to reduce it into a written document, submit it to the DPAI for certification, and they have to approve it, and a copy of that becomes a public document. So registration is a very difficult process here. For that, government may say that you can provisionally register at the end of 9 months, maybe submit the PBD policy within the next 6 months. That kind of distinction note can be done either in the actual notification, or the DPAI may give certain time, all within 24 months. Now, nothing prevents the government to make the Act, most of the provisions of the Act applicable within 12 months or 15 months. Okay. But probably they will not do it. 24 months is the recommendation of the GPC, remember, not yet into the Act. This is not, they have not made the amendment to, or at least suggested the amendment to that particular section in which this particular provision is there, to say that the Act may be made implemented at different points of time. Instead of incorporating that there, which was there in the earlier PDPA 2018, which was removed in PDPA 2019, and now the JPC did not reintroduce it there. They have left this timeline for implementation as a recommendation, not being added into the amendment. Okay, so some changes may happen here, and hopefully 2 years time will be given. Yes,
so
Rajesh?
one more related question. So
yes,
when we are saying for a data fiduciary to submit the privacy by design policy and other related documents, from an organization perspective, what is the internal timeline to implement the DPA? How do we read it like that?
in case they say that registration should be at the time of registration, they will give a form or something like that, and they may say that it should accompany the privacy by design policy. Then that is the time. By the time you start registering, you may have to be ready with a copy of the privacy by design policy. Okay, but if they give something like a provisional registration and a final registration, probably you will get a little more time. Okay, no, but not more than 24 months.
No, my question was, my design privacy by design policy is ready, but in the organization, I will take 6 months to implement it. Is that time considered as part of that 24
within 24 months? It has to be done within 24 months, because after 24 months, you may be considered as somebody for whom penalties may be implemented if the DPA finds something is not okay. Okay. So implementation also should more or less be completed within 24 months.
Okay.
Okay, and most of you are aware that this DPA policy is a very complicated thing. It has to talk about organizational methods, technical methods. It should be a compendium of all the DPIAs of all the processes. So your entire record of processing list, each of the processes you have to identify whether DPA, that is data protection impact assessment, is it required or not required? If it is required, what is the policy? All this has to be done before you finalize the this privacy by design policy. So it is a massive exercise. Better even if you say subsequently also, once you get registered, your processes will be dynamic in the sense that your PBD policy may have to undergo frequent changes. Whenever a new DPIA is, that is the impact assessment is created, you have to submit it to the authority and then say that this modifies our PBD policy submitted on such a date. Until, say, for example, next 1 year, when you may give a comprehensive revised PBD policy. So it is a moving kind of a target. So you have one document ready for the time of, at the time of registration. Subsequently, depending upon the changes which may happen, you may have to submit, say, corrections or updations to your PBD policy. Okay. Yeah, Reena?
Yeah, got it. Thank you, sir. Clarity.
Yeah.
Yeah.
Okay. So this is roughly the implementation schedule which we may expect. Now, coming to some definitions, a few new definitions have been added which are important for us. We will also discuss it later. One is consent manager. Earlier, consent manager was a footnote to the particular section under Chapter 6. Now they have brought it as a separate definition. So apart from the data fiduciary, data processor, data principal, this consent manager is a definition which is very important for us because it is a special category of data fiduciary. A data fiduciary who actually focuses on providing a service to the data principal. Okay. And that service is that he will, on behalf of the data principals, manage the provision of consent to another data fiduciary or exercise any rights on behalf of the data principal with another data fiduciary. So in the data fiduciary cadre, there will be one set of data fiduciaries who will be using the data, personal data of people for doing some kind of a business. All your Zomato, Swiggy's, all the data processing companies, they fall into that category. They take the personal data, use it for some kind of a business. Now today, they are all contacting the data principal directly and say, if you want this service, you have to give me your name, address, etc., etc. And that negotiation is going on directly between the data principal and the data fiduciary. Now this consent manager comes in as an intermediary between the data principal and the data fiduciary. He represents the data principal and asks questions to the data fiduciary. This is your notice and you are asking the consent of my client for this particular purpose. Please tell me, why do you require this particular permission? For example, in the app, you have asked for camera permission. Why do you want camera permission if you want to supply food to this particular address? Name and address is sufficient. So this consent manager will be a more informed person who can provide a service to the data principal and filter the requests coming from the data fiduciaries. Similarly, when it comes to exercising of the rights, like right of access, right of portability, right of deletion, etc., consent manager can act on behalf of the data principal. So consent manager also collects personal data, therefore he is also considered a data fiduciary. So like we say, there is a significant data fiduciary, there is a data fiduciary who processes children's data. Here we have got a data fiduciary of a special character who is called consent manager. That has now come into the definition system. This is also one of the unique features of PDPA, as you know, because other country laws don't have this. Now, data
So
protection
consent manager is part of the organization, or how is it? Or it's a role?
It is a business. It is a separate role. Okay. An organization can become a consent manager. And when they are a consent manager, they have to market themselves to the data principals, like saying that you don't understand this notice and other things, language is an issue, and the understanding the permissions is different. The company has asked for this permission. If you ask them, they will say it is required. You don't have the capacity to argue with them.
So if we can take an example from banking or insurance company perspective, how will this work?
Say,
more like an escrow.
He is an escrow as far as the personal data is concerned. That is, the data principal appoints, like you say in the copyright, you have got a copyright society, is it not? Copyright society exercises the copyright for the principal. Likewise here, now personal data is a commodity. Now that commodity is there with me as a person. I will give it out depending upon a service which I take. Now for that, I need an assistant. That is for an expert consultant who tells me that if you are taking this particular service, if you are taking, let us say, a new, say, insurance policy, what is the information the person requires? Okay, if it is a health insurance policy, you have to give, say, health data of last 5 years or whatever is that. It is a legitimate interest of the data fiduciary. Now, if they are asking for this, most of the eKYC portions, now you ask for permission on SMS, permission to read the, have camera permission. Now, if camera permission is required, it is required only at the time of registration for KYC. Now, so it has to be a one-time permission. Now, does our apps say that it is a one-time permission? Once you give, it becomes a permanent, perpetual permission. Now, this consent manager can say to the insurance company that I will get from this person only one-time this thing for camera. Now, SMS permission, should you give or should you not give? You know that SMS reading permission, once you give, your SMS consists of your bank information and other things. So anybody sitting in that insurance company can read your banking information, and one of them may misuse that. So there is a risk associated with it. So as a consent manager, I may put a restriction that you may read only SMS, which for a certain particular thing. Today, credit and other things are reading SMS messages from all your banking systems, and they know your banking balance, they know your credit card balance, and that is how they have built up their model, and they are going public with a certain valuation. But this consent manager is somebody who will put a stop to this. Now, if you look at banks, already Reserve Bank of India has introduced a framework called DIPA, that is Data Empowerment and Protection Architecture. Now, this DIPA also uses a terminology called consent manager. Who was the person who asked this question? You are asking it from the perspective of this DIPA? I don't know. Who was the person who raised this question?
Kiran, is it Kiran?
Yeah.
Yeah. So DIPA has got a mention of consent manager, but don't confuse DIPA consent manager with PDPA consent manager. DIPA consent manager is an intermediary, technical intermediary. He does not have visibility to the data. He is only a platform, and he has got the data principals on one side and the data user on the other side. Data provider, data user. Now, if the bank wants information, his request is conveyed through the consent manager network, and it goes to the customer. Customer provides the data. It comes through this network and reaches the bank. Now, here the consent manager, in some cases, the bank itself may be a data provider, and there may be a third party who is a data user. So when the data user asks for information, it passes through this data, this consent manager under DIPA, which is a technical intermediary. The consent manager maintains the platform, but he does not know the actual flow, like your UPI network or something like that. Whereas the data fiduciary's consent manager under the PDPA, he has got full visibility to the personal data. He knows, in fact, the data principal is a client of this PDPA consent manager. He provides all his information. In fact, the consent manager has the capability of pseudonymizing the data, de-identifying the data, and releasing only partial data to the data fiduciary based on the purpose and requirement. So this consent manager will act as a repository, trusted repository of personal data. It is a beautiful business model, and it has got its own potential in terms of business. So it can be there for insurance industry, it can be there for banking industry, but banking industry, you know, Reserve Bank of India will say, I have got some sectoral regulatory powers, so we have to see how it works out. But like your copyright.
Naavi sir.
Yeah.
Naavi sir, Suresh here. So you're saying this consent manager is not exactly an individual. It could be a third-party organization which can actually, on behalf of the data fiduciary, they can take up responsibility of maintaining the consents of each individual data principal. Is my understanding correct?
Correct. It can be an individual also. Nothing bars the person. He should be a person. Okay, if I make you my contractual person, I can call you a consent manager. But remember, consent manager requires registration with the DPAI. He cannot be any power of attorney holder.
Exactly. So this person or whatever, you know, this organization has to be registered as consent manager. So
Correct.
That's a separate category.
Correct.
Is my understanding.
Correct.
Okay, so in that case, if the data fiduciary themselves want to handle this, so how does it work? They may
have to wear two different hats.
Okay. Yeah.
Because there will be conflict. If I am the consent manager for my own data fiduciary, there will be a conflict. Okay. But I can be a consent manager. I can provide that information to 100 other data fiduciaries.
Okay. So
my job or my work should be limited to collecting the data and releasing the data.
Okay.
Or some kind of a regulation thing based on the trust.
Yeah. So Act itself is actually, you know, trying to give, you know, businesses another model of, you know, an income, you know, by this, you know, this, you know, suggestions or the provisions in the Act.
Definitely.
Yeah.
We have discussed this 3 years back, if you remember.
Correct.
Yeah. You're right, sir. Yeah. Thanks.
I think this is already been introduced in the
consent manager is like an advocate. He will represent you, and he can represent n number of other people also. He is like an advocate that who is acting on your behalf with various fiduciaries.
Yeah.
No, but is there a different yardstick of measurement of this consent manager? Because see, I'm sorry, like, you know, I just stopped this conversation. So, but see, because they are a data fiduciary with a much larger responsibility because since their model is supporting many organizations, which is
Correct.
not exactly as this thing. So, is there a different measurement for them on whether they're capable?
In the notification, the Data Protection Authority is expected to come up with the requirements of a consent manager and other details. So we have to wait for that regulatory notification.
Sir, one more related question.
This is already introduced in the banking by Mr. Nandan.
No, that's what I'm telling. Banking consent manager is an intermediary under the Information Technology Act. He does not have visibility to the personal data. He is a platform which transmits the personal data from the data provider to the data user. Whereas this consent manager has visibility to the data. So the terminology may be looking same, but it is different. Consent manager under DEPA is an intermediary under Information Technology Act bound by Section 79 of the ITA 2000. Whereas consent manager under the PDPA is a data fiduciary, specially registered as a consent manager with his own responsibilities, etc. So don't confuse the two. The name they should have actually avoided this conflict, but I think we have to live with that conflict right now.
Now,
Sir,
Mr.
one
Manish,
very
to
brief
simplify
question.
one thing, will CDSL will treat it as a consent manager because they have personal information as well as the financial information.
I didn't get. Please repeat.
CDSL, the body who takes care of the eKYC and other part for DMAT and
they handle sensitive personal data. Okay. So now there the question will come: who will regulate them, whether it is RBI as a sectoral regulator or the PDPA or the DPAI. And DPAI is a cross-platform regulator. And actually, when it comes to personal data, it should have a kind of a power over all other sectoral regulators. But obviously, we expect that there will be an arrangement between the Reserve Bank of India, SEBI, TRA, and others, along with this DPAI, so that they will perhaps coordinate these issues which impinge on each other's current responsibilities.
Sir, in the case of National Skills Registry, which is under the Government of India, will that organization play a role as consent manager in the future? How the employer-employee relationship matures, or even the contracts which are signed at organization level, will there be a routing from the data from the National Skills Registry?
They are themselves giving another service, no? Because they are giving reports or something like that.
They are data fiduciaries, sir, because the data that is collected in the National Skills Registry or anything, or even the CDSL, the other references, the objective, the vision of the organization is to manage those things. So they collect it directly from customers. So in that event, if there are other ways for legitimate interest, if they have to share it, it will go under that. So consent manager is purely an entrepreneurial or a business concept which will identify certain trustees who will manage the data directly on the portal or platform that is managed by that consent manager entity, which will act like a broker, and it will also handle like a legal advisory. So I think we are confusing with, because National Skills Registry or the CDSL or DMAT services or the credit cards, whichever we are talking, where the data goes to CIBIL, I don't think CIBIL and all will become like a consent manager, because I think that objective or the vision of interpretation is very different from the concept of consent manager is applied. This is my understanding.
Correct. Each of that will be a data fiduciary with their own business model. Consent manager has to be somebody who is not having conflict with any such things. He has to be an independent trustee of the personal data. Okay, so that's why I said that somebody who is a data fiduciary, he wants to also become a consent manager. There is a conflict which needs to be resolved. Then perhaps a different organization has to be set up, or arm's length relationship has to be maintained. All these things will come. Okay, but it's an interesting business model. Definitely, it is something which has to be looked at. Kiran, I will come back.
Naavi sir, with this consent manager coming in now, India will also see privacy B type of organizations coming into play.
Yes, but I have mentioned this earlier also. In India, if there is a privacy B India, it has to register with the Data Protection Authority and get consent for acting in such a manner. Whereas privacy B is presently not under regulations of that nature, as I understand.
Right.
Okay.
Right.
Yeah. The second definition, which is most important for us, is data protection officer. We will come back to it later on, because this is of interest to all the professionals. Data protection officer will now be a key managerial personnel, KMP. We will discuss the consequences of that later on. Then in harm, they have now added one more item called psychological manipulation, which impairs the autonomy of the individual as one of the harms. Basically, apart from the harms like loss of reputation, loss of job, and other things which are normally associated with identity theft or data loss. But this psychological manipulation and other things are a little difficult to make an assessment of, because you remember, when something goes into the definition of a harm, it becomes necessary for you to incorporate that in the harm audits. Harm audit is an essential part of every other data audit, like a data breach audit, like a DPIA. Whatever data audit you do, you have to make an assessment of what is the harm caused by a particular thing. So at that time, the list of items which are included in the harm becomes important for us. And now you may have to make an assessment. Does this particular breach or whatever is that has any impact on the psychological manipulation, something like that. So I think it complicates the concept of harm audit and data audit in general. Okay. Now, in writing includes some these things. So this why I have put it here is earlier in writing was directly linked to the ITA 2000 definition. Now they have given a separate definition. The difference is that if you take ITA 2000, then the question of course, authentication will be raised. Here, they have tried to say that in writing includes any communication in electronic form without mentioning the ITA 2000. So when it comes to authentication, probably, I'm not 100% sure, but your click wrap commitment, like I accept your personal data. Now, to make it acceptable, I think this definition has been brought in here. So we'll leave it here right now. It makes a subject matter for greater discussion later on. People like Rakesh can also look into it, compare it with what would have happened with the earlier definition, which said that in writing means as required in ITA 2000. Then I would immediately say if it is not accompanied by digital signature, then it is not authenticated. Now, perhaps there is a leverage for the click wrap system of getting consents. Okay, non-personal data breach, I have already said. Now, social media platform is another definition they have tried to introduce. ITA 2000 already has something called social media intermediary. Now they have those intermediaries which are in the nature of publishing, like the Twitters and Facebook. Now they have given a separate name, social media platform. We'll come back to that a little later. Now, the ITA 2000, the intermediary guidelines of February 25 clearly mentions that there will be a social media intermediary category, and there will be a significant data social media intermediary, and there are certain responsibilities for them, basically to verify their accounts. That is, the users' accounts will have to be verified voluntarily. If I want to get myself verified, then Twitter cannot say no. They cannot refuse my identification. So that is what ITA 2000 said. The same thing is being repeated in the PDPA, the DPA, but here we call it as a social media platform. The same visible mark and registration facility is also included in the social media platform. This is basically an attempt to ensure that social media platforms which handle not only the identity of the account holders, that is in the registration. You know that one of the sensitive personal information is the political opinion or something like that. Religious views is also considered as sensitive personal data. And Twitters and others express this political opinion or they say the religious affiliation. So the content in a social media platform, which is brought under the name of a particular account holder, also becomes personal data. It is not only the name and email address or account, something like that, which is a personal data. Even the content of my tweet is a personal data, and therefore the social media platform needs to be regulated both under the intermediary category under ITA 2000 as well as here. As an intermediary, a platform which does not interfere with the choice of who will publish kind of a thing, then they will not take a decision on whether I should allow somebody to publish or not, or to give a tag or something like that. Anything which interferes with the publication will remove the intermediary status of an organization. There is an ISP which takes the information from one end and sends it to the other is an intermediary. But the moment I say, I want to see who is this person, whether this is a BJP person or a Congress person, whether I should publish it or not, once I start taking a decision on the content, I cease to be an intermediary, I become a publishing house. That is what the DPA 2021 now specifies, and they have even given suggestion that like press council, you need to have a statutory authority. We'll take another 5 minutes before we take a break. Okay. Now, coming to the obligations, which is actually the one which we normally use it for lawful purpose. Now, the section 4 has been clarified like this, which says that the processing of personal data shall be subject to the provisions of this Act and the rules and regulations made thereunder. Earlier it said, no personal data shall be processed except for a lawful purpose. And this lawful purpose was not clearly defined. So we were saying that it could perhaps include an act outside the PDPA, also as a law. But now I think what has happened is the lawful purpose is defined only with reference to this particular act. Maybe it is easier now to interpret the lawfulness. It is restricted to the provisions of this act, which means that all the 98 sections. Okay. Now, in terms of quality, that is, which is one of the principles of processing, section 8, it says data fiduciary may share, transfer, or transmit personal data to any person as part of any business transaction in such manner as may be prescribed. Now, sharing of data. See, normally what happens when you look at it from terms of quality, we are talking of updations, changes in the data. Now you are sharing the data. Now they say that the DPAI will keep a power to prescribe how the data can be shared or transferred, which could mean that even when you transfer the data from the data fiduciary to a data processor, there may be some prescriptions which the DPAI may bring in, which means that like we will be having standard contractual clauses for international data transfer, DPAI may come up with its own recommendations on what should be the content of a data contract between data fiduciary and data processor. I think that empowerment has been taken through this amendment. Okay. Now, when it comes to updation, remember ITA 2000 specifically talks about updation at least once a year. Now, PDPA or now the DPA may not specify exactly a term unless in the notifications it comes. Otherwise, the consent also may have to be revised at least once a year. Of course, updation ITA 2000 is under the intermediary guidelines, section 79. And if 1 year is considered a reasonable period there, every time you have to renew your consent, similar thing may apply to DPA unless otherwise changed. Okay. Then we have this retention of data. Now, data fiduciary shall not retain any period beyond the period necessary to satisfy the purpose for which it was processed and shall delete at the end of such period. Earlier, it said it should delete at the end of the processing. Now they have replaced that word processing to such period. What it essentially means is that such period may include period even after the completion of processing. That is the period when you have to exercise your legitimate interest and other things. So the retention is not something which you say immediately after your processing is over, it should be deleted. If you can define the purpose of processing as to include, let us say, disclosure over a period of next 6 months, then processing continues, and therefore perhaps this addition of the such period is a clarification that the processing by definition is not ending at immediately after some process is over. When it goes into the storage, maybe that is a continued processing. Probably this requires a redefinition of the purpose of processing to include the legitimate interest of the organization to keep it for a further period. So I look at it as a proper clarification. Okay, so it is here that you may have to sometimes look at what ITA 2000 says, intermediary guidelines says. So for example, in intermediary guidelines, one of the things is if you are looking at registration of a person, that data has to be maintained for 180 days, which means that if I register for an app today and after 5 minutes I delete the app, still having registered, that registration information has to be maintained by the app company for a minimum period of 6 months. So data retention is subject to, this becomes a legitimate interest, legal compulsion of the data fiduciary. Therefore, a data fiduciary has to see what are the data retention norms under ITA 2000 and consider it as a necessary compulsion for data retention as part of the DPA. And there is also a section 65 under Information Technology Act, which says that wherever law requires a particular information to be retained for a certain period, it has to be retained. Otherwise, it becomes an offense if you delete it. And whenever any information becomes an evidence, a potential evidence or a real confirmed evidence of a cognizable offense, that information needs to be retained until necessary, until the process of the crime is over, which is almost eternal. So whenever you look at data retention norms under DPA, please remember there are legal compulsions out of other laws. It may be even a Companies Act, it may be even IT Act, and that has to be properly brought into your data retention policy. Okay. So one of the other important comments which have been made or recommendation is regarding how a data fiduciary has to handle the account of a minor. Of course, again, this I'm showing it as a recommendation, not incorporated into the amendment, which means that this can later on may become part of the notification. So what the JPC has observed is that we have separate say restrictions on the processing of the children's data, which by definition means a person below the age of 18 in India. Now we ask for parental consent. Now after the person attains the majority, then obviously the parental consent which was obtained becomes redundant. It has to lapse, and you have to take the consent of the child, erstwhile child, now a major person. So what they are suggesting is that data fiduciaries has to have a mechanism by which they should start talking to this erstwhile minor or his parent and ensure that on the date this person becomes a major, you will try to get a fresh consent. Now the question arises, if you don't get consent, whether you should discontinue the services. In the recommendation, they have said that you don't discontinue abruptly, which also means that you may have to give some notice or something like that. You try to start work with 3 months before the person attains majorities and reminders. But if you get the consent of the minor before that 3 months is over, obviously it is a minor's consent. So there is no cushion period saying that consent obtained 1 month before he attains majority will be considered as a valid consent. So you have to actually wait for the clock to strike 00 hours on that day to actually get the consent of the erstwhile minor to be considered as a full-fledged, you can say, the consent. So therefore, you can start talking to the person, his parent, and set something, say, automated, so that at the stroke of 12 on that particular day, you can send a notice to that particular father saying that you cease to be the controller of this particular data, and to the erstwhile minor saying that you are the person who will have to give your consent. So then wait for him to give an affirmation and then take it as a consent. So this is what they are suggesting as a process you have to introduce, whereby you may, for example, you may not have the email address of the erstwhile minor while the consent was taken from the parent. So maybe in these 3 months, you try to get the mobile number and the email address of this person who is about to become a major. And as I said, try to automate a notice simultaneously to the father or the parent and this person, one to tell him that your consent is no longer valid, and the other to say that you have to give me a fresh consent. And maybe in that consent, you say that if the consent is not received within a reasonable time, which may be 24 hours, the service could be discontinued. Now, this aspect needs to be worked out in the form of a process. So that is an interesting recommendation which they have been put. Otherwise, if you just go by this particular recommendation and say that even if I don't get the recommendation, I will continue, then obviously the whole system will not be considered as valid. Okay, so that is about the children. And earlier, there used to be a category of fiduciaries called guardian data fiduciaries. They have removed that name, but they say that organizations, data fiduciaries who process a large number of personal data of children will be registered as a significant data fiduciary, and therefore just they have removed that nomenclature, but it will become another special category of significant data fiduciary. Okay. Now, employees is another area of importance to most of our people. What this changed section 13 says is that notwithstanding anything contained in section 11, which says consent is mandatory, okay, and subject to the provisions contained in subsection 2 here, which talks about difficulty in getting the consent because it may involve disproportionate effort on the part of the data fiduciary, which was already there in the earlier version also. Notwithstanding that, any personal data may be processed not being as sensitive personal data. So this does not apply, this exemption or whatever you are going to talk of will not apply to sensitive personal data of employees, but non-sensitive personal data may be processed if such processing is necessary or can be reasonably expected by the data principle. They have added this word or can reasonably be expected, which means that where there is a non-personal data being non-sensitive personal data which is being collected, as in the case of, let us say, onboarding of new employees or something like that, then it is expected by the data principle that, okay, it will be processed for certain purposes. Now, that deemed consent is to some extent recognized by this small modification. I hope people who are the HR managers and others should consider this as slightly enlarging their ability to process personal data. Otherwise, they were only limited to a justification that it would involve disproportionate effort on the part of the data fiduciary. Now, to this, you can also add this excuse that this is something which should be considered as reasonably expected by the data principle. So I think to some extent, the work of the HR manager has been little eased. Okay. Now we come to the exemptions. You know, consent is mandatory. That is section 11. Then subsequently exemptions are given for consent for the government for law enforcement purposes. And then there is a section 14 which talks about exemption of consent for the private sector. Now here already it stated that exemption is available if the processing is necessary in the interest of the data fiduciary. They have just expanded that to add the word legitimate interest. Other than that, mergers and acquisitions is one situation where processing can be done without consent. Now to this, they have added any corporate restructuring as also similar to mergers and acquisitions. So in such cases, consent is not required. Apart from this, as you are aware, that consent may not be required in the case of information security, fraud prevention, then the credit scoring, then search operations. There are many other exemptions which are provided earlier. Now to that, they have expanded the mergers and acquisitions to include corporate restructuring. Okay, so this is an exemption clause for consent for the private sector. Now coming to the rights, one of the important changes which they have made, which may also be subject to some more legal debate later on, is that they have provided something like a nomination. What they have said, you know that under the Information Technology Act, Section 1, subsection 4, Schedule 1 says what are all the provisions under which the Information Technology is not applicable, the type of documents to which Information Technology Act is not applicable. And one such requirement is that if there is an electronic document which can be considered as a will. What do we mean by will? It includes something called a testamentary statement, which is if I say that something will be effective after my death, that is called a testamentary statement. And such statements are not valid if it is expressed in electronic document form. So this is what Information Technology Act says, that there is an exclusion of the will or similar documents from the legal recognition which is there in Information Technology Act. So it is not a legally recognized document at all. Now, in the Personal Data Protection Act or this Data Protection Act, what the government is saying is the data principal shall have one of the rights or options to nominate a legal heir or a legal representative as his nominee. They use the word nominee. You know, in banking and other things, there is a separate nomination section which is there, I think, in RBI Act. So it is legally provided for. And we all have an understanding that nomination of a bank account essentially means that on the death of a particular person, the account holder, the bank is discharged of its liability by making the payment to the nominee. It does not mean that the nominee is the legal heir for the amount. Nominee receives the money in trust on behalf of the legal heirs, and it is his responsibility to discharge that responsibility like an executor of a will. However, before the bank makes payment to the nominee, if there is a legal notice from any of the persons saying that I am a legal heir and I don't want you to make payment to the nominee, normally banks consider such kind of objections as valid objections which cannot be ignored. So either they should defer the payment to the nominee and perhaps advise this legal heir who has raised an objection to go to a court and get me a court order within a reasonable time, failing which I will continue and make payment to the nominee. This is normally the procedure which banks follow, that even when there is a nomination, if there is an objection raised by somebody claiming to be a legal heir, we suggest that person to go to a court and within the next 1 week or something like that, give me a court order which should say that I should not make the payment to the nominee. Then you decide in the court itself who is the legal heir, and then I will pay. Until that time, it will remain in the bank. But before that time, if I have discharged, made the payment to the nominee, then you come back with this objection, then I will politely tell you that this was nominated and therefore we have made the payment to the nominee. You have any objections, you please take it up with him legally. That is how bankers handle nomination of bank deposits. Now, here the word nominee has been used to exercise the right to be forgotten, the term change, the terms of agreement. But legally, the conflict here is that we know that the consent is an agreement under the equivalent to the section 14 of the Contract Act. And if it is an agreement, then on the death of a particular person, the agreement becomes null and void. So any person appointed under an agreement for any particular purpose, even as an agent, that agency gets terminated on the death of the principal. This is what general lawyers are aware of. And therefore, the nomination agreement which they are talking of under this section 17(4), if I say in the consent that I give you consent that you may let so and so to exercise my right for to be forgotten or anything else, or change the agreement to XYZ, that whether it is valid or not, both because it is a type of document which is exempted from legal recognition under Information Technology Act, and also because a contract of contractual term of a deceased person, whether it will be valid or not, unless it becomes a will, there's a separate validity required for that. There is a slight doubt whether this nomination facility, as has been suggested, is legally sustainable. But anyway, it is there and it has been given as an amendment. We have to wait and see how this will play out in the actual usage. Lemay, you have any view on this? Dr. Lemay?
No, currently not, sir.
Yeah. Okay. Yeah. Yeah. Now, there are two sections, section 18 and section 20 under the rights. Section 18 spoke about the right to correction and erasure. Right to 20 was right to be forgotten. Earlier, there was some confusion or overlap between these two sections. But now I think slightly it has been corrected. Now, the new section 18 subsection 4 says where the data fiduciary corrects shall also take necessary and practicable steps to notify all relevant entities, which is necessary when you are having subsequent transfers of the data. And there you have to actually take a decision based on the impact of the correction, which may have on the rights or interests of the data principal, which means that if there is a correction, you know that when the correction is to be made, there are two channels through which corrections may be made. One is data principal himself may ask you to make some corrections. Second is you as a data fiduciary may get some additional information because of which you consider that my old information about Mr. X is not correct, I have to update it. In such case, the data principal may agree or not agree with the change. And when there is a dispute, the law says that you have to provide your version, and you also make a mention that the data principal doesn't agree with this correction. This is the version he would like to maintain as his personal data. Now, if the data principal is not agreeable for this both versions to be present in whenever this data is further disclosed or something like that, then the only option is to go to the dispute resolution mechanism, which goes to the adjudicator. Now, when this disclosure happens, whether that disclosure requires the consent and other things, or whether you should disregard, all this depends upon the kind of harm which may be caused by the disclosure, which means a harm audit is required whenever there is a dispute between the data principal and the data fiduciary in terms of updations, because updations may be correct or may not be correct. And particularly remember that in the sensitive personal information, if we take a public, say political opinion, psychological impact, religious opinion kind of a thing, which are all actually inferences or profiling kind of data. This profiling, it is not definitive. You use some algorithm and you believe that your algorithm is the best algorithm, and you decide that this is the profile of the particular person. Now, there is no guarantee that your profiling is correct. So whether you have, after revising that, whether you need to actually inform the subsequent people and other things, you may require a sort of an assessment to be made, which means that whenever correction is required, a policy statement should be, a policy should be there to decide whether this correction is significant enough to be informed both to the data principal as well as to the other person, or it is an automatic thing. For example, age. change from minor to major or something like that, it can be automatic. You don't require anybody else's by the elapse of time, certain things change. So those things can be done without any concurrence from anybody, but there may be other things where concurrence is required. Now, coming to data portability as a right, it includes under the exemption any judgment or order of the court or tribunal or a quasi-judicial authority. This is just a minor extension. Even earlier, the provisions of portability was subject to the requirements under law and order. If a court wants, you can port it, kind of a thing. Whether the person agrees or not was not a question. Same thing now extends to the quasi-judicial authorities like the appellate tribunal, adjudication authority, and so on. Otherwise, I think this is a natural expectation. Now, under the section 20 of right to forget, the earlier section spoke about disclosure. That is, data principal shall have the right to restrict continuing disclosure, and that was considered as right to be forgotten. There was a doubt about what happens to the processing. Continued processing was anyway not permitted under section 18, which said that data, once the processing is completed, there is no other legitimate interest, it has to be destroyed. And this is also part of the principles of processing. So either by the principles of processing or by section 18, the data which was being processed and after the processing is over, there it had to be deleted. Now that deletion was not exactly similar to the right to forget. Deletion is from a process and from active use. Right to forget is like anonymization, that the organization should not remember that they have ever processed this particular kind of a data. If you take that extreme stand, there is a difference between deletion of data from a process and disclosure of data. Earlier, the right to forget was only related to the disclosure part of it. Now, the new section says data principal shall have the right to restrict or prevent the continuing disclosure as in the past or processing of his personal data by a data fiduciary where such disclosure or processing is being objected to by the data principal. So this right to forget is now extended to a firm right to stop further processing of the personal data. Maybe this is an improvement over the earlier drafting, and it gives some additional rights to the data principal. Okay, now we come to another interesting aspect, section 23 under the compliance, where it says that every data fiduciary shall take necessary steps to maintain transparency in processing. So that is why we have the data protection impact assessment, we have got the record of processing, etc. Now it says, where applicable, fairness of algorithm or method used for processing of personal data should be part of the disclosure. That is, when we are telling that data fiduciary has to provide disclosure of the processing, this extends to the algorithms. You cannot say my algorithm is a black box, I will not tell you what it does. Maybe you may not share the code, but the purpose or the processing which undergoes within an algorithm may be part of the disclosure which is required. And this has a lot of implications on the technology aspect. It affects the rights related to patent and other things perhaps, and the trade secrets. In fact, trade secret is something which the JPC has considered as not very great right, and they have tried to remove that trade secret as one of the grounds under which data sharing or disclosure is prevented. So the same thing is extended here, that algorithm or method used for processing may be part of the transparency requirements. Now coming to the section 20, yeah.
Sorry, sir.
Go ahead.
So on the compliance transparency algorithm, is it not that sufficient enough where we have substantial questions in the form of an FAQ made part of your privacy notice sufficient? Is there anything that has to get into the code level? I mean, because I think the OIC,
code level, it is not related to code level. There has to be a description of what this algorithm does. You cannot be completely blindfolding the data principle. You may have to just describe, like you said, FAQ may be one method by which you can explain what this algorithm does.
Okay.
Yeah.
Thank you, sir.
Yeah. Now, data breach notification, as I told you, that the Act says that it is applicable to non-personal data. Now, that is there in the applicability, but when you go into the other 98 sections, where is it stated that this has to be done for non-personal data becomes important, because rest of the 98 sections, if it all related to personal data, then this amendment to applicability section is only a cosmetic change. So out of the whole section, section 25 is one place where non-personal data is mentioned in terms of data breach. But it says the authority shall, in case of a breach of non-personal data, take such necessary steps as may be prescribed. As of now, nothing has been prescribed because this is an act. It will come in the regulations. Other than this, they have clarified that the data breach reporting has to be done within 72 hours. Earlier, this 72 hours or whatever was left to the discretion of the Data Protection Authority to be told in a regulatory notification, but now they have brought it into the main act. 72 hours is the time within which, after becoming aware of the breach, the data breach has to be reported. And as earlier provided and maybe clarified a little better, now data breach is reported to the Data Protection Authority, and then whether the data breach has to be reported to the data principal or not may depend upon an assessment of the severity of the harm, and the authority may direct data fiduciary to adopt any other urgent measure. So perhaps the most important thing is to report it within 72 hours, then also take a view whether this harm is significant to decide whether it should be reported to the data principal directly. Otherwise, you can always wait for the authority to tell you whether the data principal has to be informed. If you do not want to inform the data principal, obviously, when you report the data breach to the Data Protection Authority, you will have to explain what is the harm caused, why you don't consider the harm to be significant, and therefore why you have not so far given the report to the data principal. You have delayed the reporting of the data breach to the data principal, which has to be justified. Now, this is important because in case there is a further harm caused to the data principal, which can be attributed to your delay in reporting, then you may be held responsible. Okay, so within that provision, you can wait for the Data Protection Authority to tell you whether this is significant enough to be reported to the data principal or not. Now remember,
so in case of psychological manipulation, there is no guidance, right? I mean, what needs to be provided to support that?
So you will have to develop that guidance as a harm audit principle. When you develop a policy for conducting a harm audit, you may have to perhaps provide some explanations to this, unless of course we know that DPA is going to come up with a series of notifications. See, what is going to come when the act is passed is only the basic act. Now, first 6 months, the Data Protection Authority will come into existence. Then afterwards, from the 6th month onwards, the Data Protection Authority has to keep on releasing one notification or the other, and they may include all these things. What is the harm analysis? Until such time, we will have to develop our own assessment of how to conduct a harm audit. Okay, so in that you may have to look into defining how you will interpret the psychological harm.
Okay.
Okay, yeah. Now remember that when we talk of non-personal data, there is already a legal system by which the reporting of data breach is mandated under Information Technology Act 2000. This particular notification, dated as recently as 2017, says that any individual, organization, etc., may report the incident to CERT. It says may here, but subsequently, if you look at the other these things, it is mandatory. You cannot say that I will take a discretion not to report. Okay, type of incidents to be reported: targeted scanning, compromise, unauthorized access, and so on. All these were thought of in the scenario of cyber security. But remember that when you say information data breach incident, it may include breach of personal data as well as non-personal data. So as of now, CERT-In is one authority which is the authority to receive the data breach notifications. Probably when DPA comes, the CERT-In may give some kind of a clarification saying that as regards the personal data breach, please report it directly to the Data Protection Authority, because that is primarily in control of the protection of personal data. But it doesn't mean that the CERT-In will say that don't report it to me, because this distinction of personal data and non-personal data may be different from what the company does and what these regulators do. So presently what is going to happen is data protection law is now clear that report of both personal data breach and non-personal data breach has to be reported to them. And as of now, they have said that we will give further instructions on how to deal with the personal data breach and how to deal with non-personal data breach. I will think over and give some kind of a guidelines. Same way, the CERT-In may also make a statement that when there is a data breach, without trying to find out whether it is personal or non-personal, please first report it to me. Then I will tell you, in case of non-personal data, I will tell you what you need to do. In case of personal data, please wait for instructions from the DPA. This is what is likely to happen between the CERT-In and the DPA. They have to come together and put up a common, say, platform in which the report is made simultaneously to both the organizations, and both organizations immediately perhaps have a person to coordinate the advisories to be issued to the particular company, and they have to work together. So this is something which the DPA has to think of as we go ahead. Okay. Now, social media platform, I already made some mention. This, in terms of the amendment, has been brought under the section 26, which talks about the classification of data fiduciaries as significant and non-significant. And there, the social media platform has been defined as a kind of data fiduciary. And already ITA 2000 has some kind of a threshold, 50 lakh registered users from India, as the criteria for determining whether an social media intermediary is significant or not. Maybe similar thing can be used here, or DPA may come up with its own cutoff points. Presently, what it says is, if the users are above a threshold as may be prescribed, that will be one criteria. Otherwise, there should be a significant impact on the sovereignty and integrity of India. Then also it will be called a social media platform. And if it is processing the children's data. And they have also admitted under section 26 that sectoral regulators will be taken into account in terms of advising the social media intermediaries. In fact, they have suggested that, like a press council, there has to be a statutory regulatory authority for this social media platforms also. So those are the things which will come up in due course. But what is required or expected of the social media platforms is basically to ensure identity of the people who are posting information in that publishing platform. And what it says is the user, if he wants to voluntarily verify himself, he should be given the permission, and the social media platform must make whatever technical requirements are there to verify the account and display a visible mark of the verification. So it is not a restrictive kind of a provision. It only is an exercise of the choice of the data principle that my Twitter has to come with my name stamped on it. This is a choice. Twitter has got no reason to say no. Today, Twitter has got a blue tick mechanism, but their blue tick mechanism doesn't work for everybody. If I and you try to register, perhaps you may not get the registration of the blue tick because they have their own methodology. But now what will happen is DPA will say that if you are provided with, let us say, for example, Aadhaar or some other KYC, then you cannot say that you are still not ready to put a blue tick on the particular person. So that power of the platform to decide whom to verify, whom not to verify has been taken out of them, and it goes into the authority. Okay. Now we come to another important aspect, which is the auditing. Okay. Now we know that under the section 29, it is mandatory that all significant data fiduciaries have to conduct an annual data audit by an external auditor. So now this data audit is explained of what is a data audit. Data audit is an audit of the compliance of various provisions, which means that whether there is a privacy policy, whether there is a proper notice, whether the notice is understandable, whether there is the rights management, whether there is a grievance redressal mechanism, all these things will have to be checked. This is not a financial audit kind of a thing. It is an audit of the privacy practices used by the organization. We may check whether there is a privacy by design policy. In fact, if I am auditing, I will have to start with the privacy by design policy submitted in the past, immediate past, and I will ask where is the copy, whether it is certified, whether the Data Protection Authority raised so many queries, how did you answer, and so on. Then I go into the DPA, that privacy by design policy, and say whether it is properly written, whether you have conducted all DPIAs wherever it was required, and if you have come to a decision that a particular processing does not require a DPIA, where is the record that somebody reviewed it? Now, whether the record of processing or the list of processes are properly listed, whether nothing has been missed, all these things will be part of the audit. Now they have brought in a concept that apart from this annual audit from an external auditor, the DPA shall encourage the practice of concurrent audits, which means that audit is no longer an annual affair. Even earlier, you will remember that we used to say that during the year, the DPO should conduct audit in the same lines of what the external auditor would do at the year end, including calculation of the DTS. Kiran has asked about this, that data audit, and which requires a data trust score, whether it will be published. Data trust score is a part of the transparency, which has to be part of the notice, which is given to the data principle. It has to actually also appear in annual reports, maybe in the website also. Though some people may say may be published or something like that, there has to be a logic if it is not to be published, which obviously means that if the data trust score is very low, it means that you have got a negative rating. Like if you go for a debt rating and the CRISIL gives you minus rating, you would not like to publish it. Same way, when the DTS is very, very negative, you may not publish it. But if you want to raise further personal data, This PDPB policy is like a prospectus which you raise for money. When you want to raise money in the IPO, you have to give a prospectus. Likewise, when you want to raise personal data, you have to give a PBD policy. There, even in some kind of say small font, DTS may have to be revealed. And remember, the Data Protection Authority has a right to publish a list of significant data fiduciaries on its website along with the DTS score. So even if you don't want to put it on your website, it is likely that the Data Protection Authority will put it against your name. Like today, if you want some information about a company, you go to MCA site and check. You may not have given some information in your website about your directors and other things, but if I want to check, I will go to the MCA site. Likewise, the DTS requirement will be published by the Data Protection Authority on its website. Whether you would like to hide it is a thing which you have to decide. If you hide it, obviously some consultants or privacy activists will say that they are hiding it because DTS is low. It is better to be more transparent about DTS and say that we are taking steps to improve our DTS in the following year. So
this will be applicable for data fiduciary or only significant data?
Only significant data fiduciary. Okay. The filing of PBD policy is required for everybody, but this data audit and other these things are mandatory for the significant data fiduciary. Okay. Now, for conducting this audit, DPA will register persons with adequate expertise, etc., which was also there in the earlier thing, which is essential even for any such things. Like, as I have always been telling, like the patent office trying to conduct examinations and accredit patent advisors. So same way, here also, the DPA may introduce certain accreditation criteria for data auditors. Now, what people like us are doing in FDPPI, doing a certification program, is with the hope that we try to equip the requirements of what DPAI may expect from these auditors, and we give a certification. Now, we don't know whether the certifications will be automatically considered acceptable by the DPAI, which we don't expect like that. But even if the DPAI introduces an examination, people who have been certified by FDPPI will perhaps be able to easily clear that examination. And therefore, our certification is a first important step towards the obtaining the accreditation. These accredited data auditors constitute a very important profession in the coming days, because significant data fiduciaries means that there could be hundreds of significant data fiduciaries. And if all of them have to go for data audits, their current statutory auditors, the chartered accountants, would not be capable of conducting a data audit. So therefore, this is a good profession. And okay, just as we are doing it, we were one of the first people to start doing it, develop a program and call somebody as a certified data protection officer kind of a thing. And we also developed a certain, say, audit framework. All that we did it voluntarily. We have to wait and see now how the government, the DPAI will prescribe what should be the accreditation of the data protection auditors, what should be the framework. All these things will come. And as and when the DPAI provides its views, we will also perhaps ensure that our training as well as the framework will undergo an appropriate updation. One of the recommendations which is also important for us in terms of audit is that the committee has made a recommendation that the data fiduciary, okay, should maintain a log of all data breaches, both personal and non-personal, and that should be reviewed periodically by the DPAI, which essentially means that the incident management register of the organization may be the one which the Data Protection Authority will frequently ask for copies. Maybe, I don't know, they may say that once in a quarter you have to submit your quarterly incident register to me and let me review that and consider whether an audit is required or something like that. But remember that your incident management register now may be open to scrutiny and audit by an inspector from the Data Protection Authority. And of course, there they may also decide how you have defined an incident and whether the definition of the incident is taking into account the contravention or suspected contravention of any of the provisions of the Data Protection Act, because that is what becomes an incident for an incident register maintained under DPA 2021. If you are maintaining an incident register for your ISO 27001, that is different. That is a technical register. But from the perspective of DPA 2021, if you are calling something as an incident register, the definition of incident will include that any contravention or suspected contravention of any of the 99 sections will be considered as an incident. Now, for that, the people who report incidents, which means that essentially every employee of the organization should have some idea about what Data Protection Authority Act says, and there should be a method by which the people on the counter, which may be help center people, will identify that certain complaints they receive may have an element of a Data Protection Authority Act violation, and they should be able to escalate it to a more informed DPO or something like that. So an organizational level awareness creation, at least to identify potential incidents, is absolutely essential as soon as this Data Protection Act comes into being. Okay. Now, before I go into Data Protection Authority, I will just take up another question which Kiran has asked. What category will insurance companies will be classified as? Insurance company, if it is doing business in India, collecting and processing the personal data in India, it will definitely be a data fiduciary, and it will also be a significant data fiduciary because they collect sensitive personal information, whether it is life insurance or health insurance. You collect health data. Health data is a sensitive information. Therefore, all insurance companies will be significant data fiduciaries, both by the nature of data as well as the quantum of data. Okay. Now we come to this Data Protection Officer. Now, the new section 30 says a very significant data fiduciary shall appoint a Data Protection Officer. This is the adjective they have now added. Who shall be a senior level officer in the state, that is for the government data fiduciaries, or a key managerial personnel in relation to a company or other employee of equivalent capacity. See, earlier we were all telling that the DPO has to be a senior level person. He should report directly to the top management. Ideally, there should be an apex governance committee where an independent director will be the chairperson and DPO will report only there. This was something which we were telling, so that this was the understanding. Now that has become part of the law, because the law itself says that he should be a KMP. This key managerial personnel is not just an English word. It is a defined set of say role in the Companies Act. So in fact, if you look at this section 30 further in the explanation, it says key personnel, managerial personnel means a chief executive officer, company secretary, whole-time director, chief financial officer, such other personnel as may be prescribed. This has been just taken out from the Companies Act as a cut and paste. So a direct relationship between the definition of the KMP in the Companies Act and this Data Protection Act has been established here. Therefore, we have to see that the level of the DPO should be on par with the KMP. If the KMP says it is equivalent to a whole-time director, CFO or CEO, obviously we are talking of a DPO who is almost on par with the CEO. And company secretary is a category of profession where, though company secretary is an employee of an organization, is paid salary, he has got a fiduciary responsibility to the shareholders of the company, and he directly reports in certain cases to the regulatory authority like SEBI. So that person has been added here. Now, why CFO is here? Because they have just used the KMP directly from the company secretary. Otherwise, maybe the CFO as well as CEO are persons who have got some kind of a conflict with the DPO activity. Company secretary is a person who knows how to deal with conflicts, where something about the interest of the company may be adversely affected, but he has got a duty to the shareholders. He knows how to handle it. So the DPO is expected to be something like a company secretary. So either the company secretary himself can become a DPO, we don't know. Otherwise, the attitude of the DPO should be similar to that of the company secretary, where he has to remain himself immune to being influenced by the company executives and ensure that his loyalty to the DPA and his duty to the data principles is not affected by him being part of the management team. In fact, the key management personnel, one of the things which may directly affect us is that he can be appointed only by a board resolution according to the Companies Act, which means that a DPO also has to be appointed by a board resolution. You cannot have CISO issuing an order or a CEO issuing an order saying that you are appointed as the DPO. DPO appointment has to be a board resolution, and that board resolution should have terms and conditions of appointment, details of remuneration, and very important, age not exceeding 70 years. So a DPO has to be of age less than 70 years, which means that automatically 70 years is the retirement time for the data protection officer. And there has to be a board resolution, and an appointment, including remuneration, should be part of the board resolution. That is the level of importance which is being given to the data protection officer.
Sir, can't see your screen, please.
Pardon?
We can't see your screen.
Since when?
We can.
Yeah, we can see.
So
Rita, maybe you have to just.
I will stop the share and reshare, okay?
Yeah, thanks.
No, it's visible to us all, Naavi. Okay,
Right.
maybe some problem at his end.
Okay.
Yeah, Naavi, it's looking fine. Go ahead.
Okay, fine. Okay, we'll go ahead then. Okay, maybe something about your this thing, you just check that. Okay. Now, any questions on this? Data localization section, I will come.
Naavi sir,
Yeah.
with regards to the DPO, the other data protection law like GDPR and all does not have specifically mentioned the DPO position like the Indian DPA is now recommending. Does that mean that organizations needs to have multiple DPOs?
Can have multiple DPOs. After all, a DPO under GDPR does something which is not related to this. No, he is only looking at the interest of the EU citizens. Here we want people to look at the privacy interests of the Indian citizens. So if the same DPO can do both, it's fine. Remember, in the case of our BPA, the DPO has to be an employee. He should be located in India. In the case of GDPR, he can be located in India, even if the processing is under the GDPR, fine. And you can also appoint somebody by way of contract, which means that an external person also may be possible under GDPR. But under DPA, he has to be an employee of the organization. You may still have an external consultant. There is nothing wrong in having an external consultant to support your DPO. Now, you may have the same person for GDPR and this, there is no bar on that. And you can even have in large organizations, I feel you may require multiple DPOs anyway. Even today in GDPR also, you may have multiple DPOs because say if the location wise you have got multiple locations, the DPO sitting in one place, it's always more effective to have a sub DPO. You may have one DPO to interact with the regulatory authorities, but within the organization, you can always create a team. How you designate it, each of the people is left to you. So there has to be a team. And of course, externally, there will be one person who is called the DPO. Okay.
Now, sir, just one
Also,
question.
sorry, I just have a connecting question with the previous one. Previously, the PDPA was very categorical in saying that a CISO could not be a DPO because of the conflict in terms of their operations and their reporting. Is there a clarification on that?
Actually, even earlier, they had not categorically stated like that. People like us were telling that that conflict is there. And in the GDPR scenario, there have been decisions of the penalty decisions where conflict was recognized and penalty was imposed on an organization, even when a compliance officer was actually appointed as a DPO. So this conflict is something which we all had recognized, and that was not part of the law. Now, the question of CISO becoming this continues to be a conflict situation, first of all. Second, it now says clearly that DPO has to be a key managerial personnel. Now, does all CISOs are considered KMPs at present? No, is it not? Am I correct?
Yep.
Yeah. So therefore,
yeah, may or may not.
Yeah, may or may not. In some companies, he's by naturally he may be a senior person. That is different. But now law is prescribing that DPO will be a KMP equivalent to a whole-time director. So I think it actually fits him a level above the CISO. So please, those of you who are CISOs, please remember, I've told this earlier also that DPO is a destination for CISO in one of the discussions. But most of the CISOs have been jointly designated as DPOs in India in many companies. I think that procedure needs to change, and CISOs have to give up their CISO responsibility and take over DPO. Actually, that is a higher level responsibility, because your knowledge of information security will definitely be useful, but you now put in your privacy related knowledge so that a DPO is CISO plus something. Okay, please try to look at that as an added kind of a skill, and that is what the Act also seems to suggest. Okay.
Now it's just one quick question. Is the Act anywhere defines how a person could become a DPO, who would be a certifying authority, or is that still for DPA to decide?
The Data Protection Authority will provide some guidelines on the requirements. Right now, we know what is there in the Act. That is, the DPO should supervise this technology, so it should advise the company, should be able to be a single point contact with the data principals, should deal with the Data Protection Authority. These are mentioned as the functions of the DPO.
Right, responsibility.
Okay. Beyond this, we may get a regulatory notification. There may not be immediately a qualification. Of course, let us see what will happen when the DPA comes. Obviously, as of now, at least, there is no, university qualification as a DPO. It will never be, because this is something that has to be taken from the industry. Okay. So people like us will continue to say, if you are an FDPPA certified person, you are better equipped. That's all we can say. We cannot say that you will automatically get accredited. But I'm sure that DPA can even start registration of DPOs. They can even, like for the auditors, I said there will be an examination, etc. They can as well have a similar criteria for the DPOs. If they do it, it is good actually. So that everybody cannot be just designated for the sake of having his name in the particular thing. At least it should be registered, and DPA may also say that whenever you make a change of the DPO, if not prior permission, at least please inform the DPA. That those things may come in the further regulations. Then only the independence will be maintained. Like when you change a statutory auditor, you may have to report to the SEBI, if you are a listed company. So they may take a view, they may not interfere with your ability or with your power to appoint a new statutory auditor, but at least they will take note that something has happened here. And probably if there is a fraud or something like that, that is considered as an indication. Likewise, in DPO appointments and the removal also, if I am advising the Data Protection Authority, I will say, please register and ensure that any person, any change will have to be reported to the DPAI. So that then it's an intelligence for the DPAI. They can try to see why this is happening, kind of a thing. Okay. Yeah.
Thank you.
Yeah. We'll come back if time permits in the end for more discussions. Let me complete some of the key other these things. Another is the cross-border transfer. Now, in the cross-border transfer, you know, as of now, there is very little restriction in the sense that personal, non-sensitive personal data can be easily transferred. Personal data which is considered sensitive can also be transferred, provided you have an explicit consent. Now, what they have tried to modify this is by saying that sensitive personal data after transfer shall not be shared with any foreign government. So you have to put this as a condition for cross-border transfer. So if you are looking at this standard contractual clauses, now SCC of India will have one provision which says that the receiving party will not share the data with any foreign government unless such sharing is approved by the central government, which means that, you remember in the case of Schrems, the dispute was that the European court wanted the US authorities to abdicate their power to ask for information, the law enforcement, FBI, and the president, or something like that. Now, here there is a similar provision, but it says that if you have a request for access of data from your government, then please contact me for approval. If I approve, then perhaps you can release. Otherwise, I have the final decision to say whether you have to disclose it to the authority or not. So this clause may have to be incorporated in all the data export.
So one question.
Yeah.
So this applies to any kind of personal data or only sensitive data, and to everybody or only significant fiduciaries?
No, this will be for sensitive personal data, because personal data anyway, there is no restriction at all.
Correct. Okay. Correct. Yeah.
Okay.
But only if, then this will apply to everybody.
It will apply to everybody, yes. And critical data also, obviously, it is more than the sensitive personal data. Okay.
So, for example, we have biometrics. Supposing somebody is trying to make a backup, or server is in some other country, then we will have to.
Biometric data, if you look at it that way, may not be even allowed for transfer. There is a separate section on biometric data in the miscellaneous chapter. Okay. I think it comes under section 93 or something like that. Bar on processing certain forms of biometric data. So there, unless the law permits, when they say law permits, which is what the Supreme Court has said about UADI, then even processing by Indian data fiduciaries of biometric data is subject to that. And it may come under critical data. You know, critical data has not yet been defined, but biometric data may be defined as critical data. So the transfer of critical data will be a little more restricted than sensitive personal data. The law may say it can be transferred on medical emergencies, on explicit consent, and when otherwise it is permitted. So rest of these things, cross-border transfer of sensitive personal data, you should at least have explicit consent, and you should incorporate this clause to the data importer that you shall not release this data to your government authority without my permission. And your permission means it is not the permission of the data exporter, it is our government's permission, or DPAI may introduce a system for that. Okay.
So how will the data which is already shared be construed?
That is a good question. In fact, in the recommendation, if you see, there is a recommendation. Okay, this is not in the amendment. recommendation of the JPC is that within a certain time, effort should be made to get the sensitive and critical data already transferred back to India. Now, of course, it is a tough this thing, but they have recognized that India being a sovereign and democratic nation, it has got the duty to safeguard the privacy, and therefore, what has happened in the past, the government should think of how to get this back. Okay, so personal data, critical data, and sensitive personal, which is already in possession of the foreign entities, should be mandatorily brought to India in a time-bound manner, is the recommendation which has been given by the JPC. Obviously, it is not an easy thing, but
yeah, that will also require government help, because if you look at this Chinese phone companies, they already have our personal data, right? If we have used the phones. So there should be a diplomatic pressure and stuff like that.
Correct. But
yeah,
the intention has been expressed here. So future transfers will be highly restricted. But what has already gone, this is the data localization. In fact, data localization has been strongly supported in the JPC's entire report. It may not appear here as an amendment, but data localization, they have discussed it in detail and said it is essential for India. And that is why some of these changes of getting back has been suggested. So as we go forward, there will be more action on this front.
Naavi sir, just even if we put it in the contract of the person to whom we are exporting the data, that you will not give it to your government without our government's permission. I mean, it's just a contractual clause. If the law of that country requires that person to give it to the police officer, I mean, that contractual arrangement will actually not be relevant, because law will supersede the contract. So, I mean, I don't know.
Yeah,
I mean, then
that law will supervise that contract, but the Indian law will definitely be applicable to the Indian data fiduciary.
Yeah, so that's the reason I feel like one needs to assess then that if in that country such a law exists, then that contract will actually have no value for that person. Because suppose it's Germany and German law requires you to give it to the police officer, then you can keep writing anything in that person's contract, but it will not matter.
The same thing applies even today when a GDPR data exporter is insisting on standard contractual clauses for an Indian person. India also, we have got the CRPC and other things. If the government wants, it can even seize you all your computers and perhaps start looking at it. Okay, nobody can prevent it. Not that they will do it, but law will not bar that. So same thing is here. The only solution in this particular case, as well as the GDPR case, is the data exporter has to look at pseudonymization of data so that this risk is not, does not arise at all. Why do you want to share the identified data for processing when you can do the same thing with the pseudonymized data? Is what you have to think. You have to actually look at the technological changes. Which
no, makes sense.
Yeah.
Thank you, sir.
Yeah. Okay. So this data localization is definitely in the radar, and because certain sectoral regulators have already implemented it, this will become part of the discussion in future. Okay. Now, under the exemptions, you know that there is exemption for government, which is for whatever permissions are available under the Article 19(2). That for law enforcement also there is exemption. Now, additionally, when defining this 35, section 35, you know that privacy activists were complaining that the power should be exercised in a proportionate manner or something like that. Even though Constitution provides for reasonable exceptions, you cannot use it just like that. So what the JPC has done is that while they have retained these words, that when the central government is satisfied that it is necessary and expedient to process, then it can exempt any agency from any or all of the provisions of the Data Protection Act is the basic thing. Now, they are now saying, notwithstanding anything contained in any other law for the time being in force, which means that they have blanket permission now to make this law prevail over any other law where people may say under Telegraph Act you cannot do this, under this act you cannot do it. Now nobody can raise any such objection. This section 35 now says that irrespective of any other act, here we are giving permission for the government to exempt, provided it is within that section 19(2), this first 8 principles. It doesn't include contempt of court, it doesn't include defamation, but rest of the things, national security, friendly relations with the foreign countries, under those grounds, you may perhaps exempt a particular agency under a certain procedure. Now, they have also added an explanation. Such procedure refers to just, fair, reasonable, and proportionate procedure. So no privacy activist now can raise any objection that the law gives unlimited powers to the government to exempt any agency from any of the data protection professionals, data protection provisions. So they have added this just and proportionate, reasonable, just and proportionate to the procedure, so that apart from necessary and expedient, these things will ensure against people challenging this law as ultra vires our constitution. So I think this is a good move, intelligent move to ensure that some of the objections raised on this particular powers are being addressed. Okay, fine. Now, exemption under 36, which is the journalistic purpose. Now, what they have said is the processing of personal data, if it is necessary for journalistic purpose, it is exempt, subject to certain rules and regulations, code of ethics issued by the Press Council of India or by any statutory media. You know that in the February 25th guidelines of the intermediary guidelines, a statutory authority like a compliance officer is being mentioned, and of course Press Council is not today regulating the internet media, so something similar to Press Council may be there for journalistic purposes, and this processing for journalistic purpose, some kind of a regulation will be enforced through a parallel organization with which like a sectoral regulator. A new sectoral regulator for digital media is what is being suggested by this section 36. Now, briefly coming to the DPAI composition, which was also something which was highly criticized. It is not relevant for companies, but still it was criticized. Earlier, the criticism was that DPAI members will be, this 1+6 members will be there, and those members will be selected by a committee of the cabinet secretary, law ministry secretary, and the IT secretary. Now, people started saying that 3 secretaries will sit there and get all their kith and kin into this DPAI. But what they have not done now is that this selection committee has been expanded to include the Attorney General of India. It includes a director from any of the IIMs. It includes a director from any of the IITs. It also includes an independent expert to be nominated by the central government from the fields of data protection, etc. So the committee is today having a wider representation. There is no FICCI or something like that, okay? But IIM and IITs are accommodated, and it also says that the members, out of the members, it is now specified in the law that at least one person should be an expert in the area of law. Earlier, it was there as a general guideline that they should have experience in law, IT, etc., data analytics. Now, they have mentioned that at least there should be one expert from the area of law, so that you cannot have only technology people in the DPAI. There has to be an expert in law, not necessarily a judicial person, okay, but expert in law has to be there. This is the composition of the Data Protection Authority. And in the powers of the Data Protection Authority, another important thing which has been done is that the DPA will have the power for monitoring, testing, and certifying an agency which is authorized by central government for ensuring integrity and trustworthiness of hardware and software. Now, hardware and software used for data protection can be subjected to a certification system for which the government is expected to set up labs for testing. So this is a new area of opportunity for technology kind of companies to ensure that their software gets certified. It is like your cyber law compliant software, or if you people who are aware of the development in the HIPAA High-Tech Act, for some point of time, for 5 years, High-Tech Act had a system of HIPAA compliant software for which various incentives were given. So here there is a system by which a lab can be authorized. It can be STQC, it may be something else. They will certify your data protection software or hardware against any possibility of malicious insertion, which means that if you are buying a Chinese software or Chinese hardware, it is to be certified by this accredited lab. To that extent, government has taken some steps. How practical it is and how difficult it is, we do not know. But definitely, Data Protection Authority has been given the powers, and this is part of the certification system which will come up now. Okay. They also suggest that if necessary, you may have to make some changes in the Patent Act, and they have also introduced this hardware certification as a recommendation, details of which will have to be worked out. Now, as I said, that there is a balancing of the needs of the government, which is been incorporated in the preamble. To that extent, some thought has gone into the JPC amendments. Now, as regards the code of practice, you know, code of practice will be given by the authority. That is always there. Now, the authority may also approve codes of practice submitted by an association, which can include a technical service organization and an organization which is working in the interest of data principles. Say now when FDPPI is suggesting that there is a PDPSI system, we are working under this principle that maybe, I don't know, maybe we will develop a framework which the authority may consider as acceptable. We don't know. We have to ensure that our framework is as good as anybody else can think of. And therefore, we are expecting that as an organization which works in the interest of data principles, we, or even as an organization in the industry or trade, we will be presenting our PDPSI, which will be renamed as DPSI because the Act itself now has changed. Our new data protection standard of India will be one of the things which will be competing for accreditation. We don't know whether it will be possible, but we will definitely try. So codes of practice will come into being. I don't know, GDPR, nothing much has come, but here we are going to have it. We already have a code of practice now before the Act comes. So we are far ahead of anybody else so that the DPA can quickly take a decision on this. Now, in terms of penalties, there is a new section called Section 62, which talks about the aggrieved data principle having the power to, it's such a procedure which was earlier also it was interpreted, but it is added here saying that an aggrieved data principle can comply to the Data Protection Authority for claiming compensation apart from the complaint resulting in penalty and other things. The compensation to the data principle is possible through the same system of adjudication. So application will have to be made to the Data Protection Authority, and Data Protection Authority will transfer it to the adjudicator, and the adjudicator will take a decision on how much of compensation has to be paid. Otherwise, there was in between a time when the penalty system was considered for some change. Like, you know, that there is a 5 crores or 2% and 15 crores or 4% of the total annual total worldwide turnover. That is the penalty. Now, for a few weeks, there was a debate in the media that the government may remove this percentage of turnover criteria for penalty and restrict it only to 5 crores and 15 crores. But in the final version which has been presented to the parliament, that has not been altered. So there are category 1 kind of penalties, which is either 5 crores or 2% of the total worldwide turnover of the undertaking, okay, which may include subsidiaries and other things, whichever is higher. And so certain kind of penalties, it will be 4% of the turnover computed as the global turnover. Okay, so that remains. 5 crores, 15 crores also remains, and the government, it is only 5 or 15 crores. There is no turnover criteria as far as the government is concerned. Now, the adjudicating officer, there is a small change. This again is not very much important for companies, but for lawyers who are looking at this, it is important. One thing is the adjudicating officers, of course, qualifications and other things will be prescribed, and some guidelines will be created by the Data Protection Authority for the fixing of the compensation or the penalties. And one more thing is that a representative application is permitted. That is, a class action kind of a thing is permitted in adjudication, so that some of the, let us say, public service minded organizations can look at taking up class action suits in the case of data breaches. So that is possible. Then appellate tribunal is being set up, and in the appellate tribunal some minor changes have been made, which is that it will have not exceeding 6 members. Say earlier this was missing. Now we were expecting 3 members will be there. Now 6 members could be there in the appellate tribunal, and here the chairperson will be a judicial person. And they have also made a provision that he should be either a judge of the Supreme Court, has been a judge of a Supreme Court, or has been a Chief Justice. If neither of that is there, even a person who is qualified to be a judge of the Supreme Court, which is a senior lawyer, can also be appointed as the chairperson of the appellate tribunal. I am sure government has some people in mind already, and maybe that is the reason why a senior lawyer is being perhaps tipped for this particular position. Okay. Now, in the case of a member, there will have to be 20 years of experience, they say, in technical knowledge, and such a person may be appointed. There is no clear idea today about what will be the way in which this appointment will be done. Maybe we will come to know of it when the notification comes. Now, as far as appeal is concerned, every appeal made under this section should be done within 60 days, and the appeal from here goes to the Supreme Court. And within the tribunal, it is possible for experts to represent the case of a victim or whoever is the litigant. So this is also something which is good to be clarified, though we know that in all tribunals, it is possible for non-advocates, that is people who are not bar council members, to represent people. This has been happening in TDSAT in cybercrime cases. Now, this has been specifically mentioned under section 77. Now, section 85 is relating to the vicarious liability of the officials of a company for the offense of the company. Now, there is only one offense, as you know, that re-identification of de-identified information is the only punishable offense. And when that happens, when a company is attributed with that this thing, every person who is in charge of the business may be held liable. But they have specified that in the case of an independent director or an executive director who is not involved in the day-to-day operations, he will not be liable unless something thing can be attributed as done with his consent, and he has been reckless and not acted with due diligence. Otherwise, persons who are in like DPO, in case the offense occurs, may be held responsible, so they have to be a little careful. Only in the case of government data fiduciaries, this criminal offense will not be attributed to an individual unless a government inquiry takes place. So they have tried to protect the government data fiduciaries, particularly earlier they said head of the office will be directly considered as equivalent to a CEO and he will be liable. Now they have carefully ensured that the head of the department is protected from any liability, and power has been given to him to conduct an inquiry under the disciplinary proceedings before any other official is held criminally liable. This applies only to that criminal section. Okay. Then the section 92 continues. This was the earlier section 91. That is, the government retains the power to ask for information of non-personal data, provided it is required for framing any policy of the digital government for the good of the public. So this is the changes which we have identified as key changes. Of course, this is a supplementary program which we conducted for our earlier trainees. In future, when we conduct another program, we may conduct it from the DPA 2021 as the base, and we may start it immediately from tomorrow. All the new registrations will be for the new DPA 2021. We will not go back to discussing PDPB and the changes. Okay, so let me end this discussion on my behalf here. If any questions are there, let us spend some time if it is okay for you.